Thank you, everybody, on this beautiful September day. I'm Larry Burnett. I'm a shareholder in the Business Organizations Department here at Reinhart Boerner. Next to me are Ben Lombard and Nate Newberger. Ben and Nate are not only in our business group, but also specialize in securities laws. I think about a month ago, I was reading the Wall Street Journal, and I saw this headline that just screamed out at me, and it says, SEC clears way for entrepreneurs to tweet, blog about unregistered shares. And it's actually an article summarizing the ability that the SEC has given through some legislation, or been empowered through some legislation to allow offerors, to advertise securities offerings in certain circumstances. So I read that and I thought, holy cow, this could really be a game changer for early stage companies, which I do a lot with. So I started reading the article, and I'll read some of the salient parts to you, with the challenge of listening to Ben and Nate and thinking whether the Wall Street Journal got the headline right or whether they didn't. So here's the article. It says, get a kernel of Quinn. Entrepreneur Coulter Lewis will soon be able to tweet such a message legally as a way to raise cash for his Woburn, Massachusetts firm, Quinn Popcorn, LLC. On Wednesday, the Securities and Exchange Commission lifted a decades-old ban on publicizing any share offerings that aren't registered with the SEC and are limited to accredited investors, typically wealthy individuals, who can afford the financial risk of investing in a new business venture. The agency's move satisfies the central provision in last year's Jumpstart Our Business Startups Act, which aims to make it easier for smaller companies such as Quinn Popcorn to raise cash from dozens of wealthy investors who might put up, say, $20,000 apiece in exchange for a small equity stake in the startup. As a result, some entrepreneurs with businesses ranging from ride-sharing apps to portable farms say they are planning marketing blitzes that they hope will help them reach the right target audience of potential investors. Under consideration, putting investment offers on billboards and even printing them on T-shirts. So, by the way, we are in the T-shirt business here at the firm. So, such marketing helps entrepreneurs save time and energy, they say, because they can bypass the time and legwork involved in having to network and make connections to find an investor. But the reason many of these laws were put into effect in the first place was to prevent fraud and to stop the public from losing money on what are typically risky ventures. If anybody would like a link to the article, I'm happy to provide that. Just get me your business card at the end, or give it to either Ben or Nate. But the real challenge here is to determine whether or not the SEC rules really do empower small companies to raise capital more easily, and determine how both entrepreneurs, angel investors might use these rules. So with that, I'll turn it over to Ben and Nate.
All right, thanks, Larry. I think the Wall Street Journal article is a good place to start because it sort of frames what some of the people are saying about this and some of the hyperbole, perhaps. I think, and I'll just give a little bit of an overview here before we jump into the details, but I think a key consideration for any issuer that's thinking about advertising is effectiveness. When I hear things of like billboards and T-shirts, I wonder how effective that's going to be. Accredited investors are a very small portion of the population, probably 5% or less. And I think most accredited investors or anything like me, I'd see something on a billboard relating to a securities offering and say, no way, I don't want to touch that company. I do think, however, that there are ways to advertise that might be effective, and I think we're going to cover some of them during the seminar. One way, for example, might be social media, Facebook pages, things like that, especially if a company might have some buzz as a way to try to find people who might really be enthusiastic about a product. Think about the things that already happen now with some crowdfunding and Kickstarter and things like that. you transfer it over to just accredited investors through advertising, you might be able to roll through social media and get some real interest in a product, and those people might in theory turn into investors. So that's one possibility. Second possibility might be things like niche products where there's logical sorts of places to advertise. Consider, for example, a medical device company that might have an exciting new early stage product that might generate a lot of enthusiasm from, say, a group of surgeons or other people who understand the business. Look for a journal or publication that targets that, maybe advertise there. That might be an effective way to advertise, to look at an audience that is likely to be wealthy and accredited investors and to be interested in that product. Or consider, for example, hedge funds and other sorts of private funds. Those sorts of entities probably have logical places, again, journals, financial publications, where they can look to advertise and go to a limited audience of people interested in that product. So I think there are ways to advertise that might be effective, but any business that's thinking about it has to think about the trade-offs. And we're going to spend a fair amount of time here on some of the trade-offs and requirements. And one trade-off is you can only sell to accredited investors. So if you're thinking about any non-accredited investors, it won't work if you advertise. And I don't think that's such a big issue because I think the private placement market is already largely limited to accredited investors in most cases, but that's one trade-off. Second trade-off, and we're going to spend a fair amount of time on this, is the requirement that you verify accredited investor status and what that requires and whether that's going to be a real turn-off to potential investors in terms of what they have to provide to verify their status. And then a third trade-off is the fact that once you go down the road of advertising, it's hard to go back. You can still do the old private placements without advertising, so you can go either route, but once you start advertising, you can't go back and start doing an old traditional private placement, at least without a cooling off period that I would say would normally be about 6 months. So if you start down the road of advertising, it's not effective, and you've got some investors who are only interested in investing the old way without verification, it's hard to say, oops, wait a second, we're going to do it the old way without verification and do a regular private placement. You probably have to wait 6 months before you can do that. So with that, I'll turn it over to Nate and start jumping into some of our slides here.
All right, before we get into the slides, I know there's not a lot of securities lawyers in the audience today, so I just want to give a quick overview of the sort of the rules that we're going to be talking about today. About 80 years ago, the Congress passed a number of acts which really serve as the framework for securities regulation in the company, or excuse me, in this country. The rules have evolved over time, but for the most part, the basic concepts that were passed in the 30s and 40s really remain today. So on one hand, Congress recognized that the public in general needed some sort of protection from fraudulent and manipulative practices in securities offerings. So they put in place a comprehensive disclosure and registration regime that if you're a company making an offering to the public in general, you have to really run through all these requirements. On the other hand, Congress recognized that there's some subset of the population that is perhaps more sophisticated than the rest of the populace. These folks perhaps should be able to fend for themselves in securities offerings, and perhaps they don't really need the same sort of oversight that public offerings are subject to. So Congress carved out a subset of basically private or non-public transactions that these sophisticated individuals could take part in. It's sort of an interesting sort of theoretical question that runs through everything we're going to be talking today is, how do you determine who is a sophisticated enough person that they're not, don't need to be a part of a public offering regime. Over time, and Ben will get into this in more detail, but it's really evolved into a system where based on income or on wealth. So if you make enough money or if you have enough money in the bank account, you're deemed to be an accredited investor and presumably sophisticated enough that you can take part in these private offerings. Does that really make sense? Is wealth really a good proxy for sophistication? It's not really clear. Maybe at first blush, yeah. Some of the wealthiest people in the country, hedge fund managers or investment bankers, are clearly sophisticated. And you sit down though and watch the Video Music Awards, and you got Miley Cyrus twerking on Robin Thicke with her tongue out, and you're like, wow, these folks are accredited investors, and they're able to take part in these offerings. It really calls the whole system into question. But the rules are what they are, and so that's really not for us to say. So In any event, fast forward from the 1930s and 1940s to 2008, and the global economy falls on its face, and Congress is looking for any way to encourage companies to raise capital. Banks aren't lending, so they're looking for any other way to get some money in the hands of those who can use it to create jobs. And so they bat around ideas for 3 or 4 years, and then finally in 2012 they passed the Jobs Act. Proposed rules were issued by the SEC in August of 2012. The Jobs Act had about 4 or 5 different provisions that were aimed at facilitating capital accumulation. The first one is the one that we're going to be talking about today, about eliminating the prohibition against general solicitation. So the proposed rules came out in August 2012. They were circulated for public comment. And then finally in July of this year, right as the Dow was hitting about 15,000, they came out with the final rules to implement the first stage of the Jobs Act. So, let's see if this clicker works. So, as I mentioned, we're talking about private placements today. Obviously, they have a very big role in capital raising in the United States. The stat up there, $900 billion raised in Regulation D offerings in 2012. Regulation D is the most widespread exemption used for private placements in the U.S. There are a few other exemptions that are used as well, and if you lump in the cash that's raised under those exemptions, it actually probably surpasses the $1.2 trillion that was raised in public offerings in 2012. So it's a sort of real rough estimate. Half of the capital raised in public transactions, half in private in the U.S. Private offerings, they can be as big or as small as you want. There's really no limit on that. You can have private placements that are as large as big public offerings, and you can also use them for small offerings by startups, medians about $1 million. Regulation D has a number of rules underneath it. What we're talking about today is Rule 506, the exemption available there. It's by far the most widely used exemptive rule for raising capital under Regulation D. So I don't want to get too deep into the statutory basis for all of this, but just to really show what we're talking about here. So in 1933, there was the Securities Act was passed, and that's how the world really got divided into public and private offerings. There's a provision in the Securities Act that says you don't have to comply with the broad registration and disclosure regime for public offerings if you're taking part in an offering not involving any public offering. Well, it's a broad, vague statement, and it's not really clear what exactly that means. So in connection with that, the SEC and Congress put into place Regulation D, which provides a safe harbor, and basically it's a set of instructions for making sure you have a private offering. It sets forth a number of rules, and as long as you comply with those rules, you're deemed to have a good, exempt private offering under Section 4H, and you're not required to comply with the public offering requirements. Rule 506, there's no limit on the amount of capital that can be raised in these private offerings. Likewise, there's no limit on the number of investors. These are quote-unquote private offerings, but with one exception, as long as everyone in the offering is an accredited investor, is a Miley Cyrus, then you're allowed to have as many of those folks in the offering as possible. Now, there's an exception currently under Rule 506 that says you can have up to 35 non-accredited investors in the offering. The problem is you start lumping in these non-accredited investors, and it really complicates matters. You have to satisfy certain sophistication requirements, and you're required to provide them with a disclosure document. And for the most part, they're more trouble than they're worth a lot of the time. So frequently when you see a Rule 506 offering, you're trying to limit it to all accredited.
Okay, and just to go back to the statistics, I think the statistics are in 2012, 90% of Reg D offerings had only accredited investors, only 10% had any non-accredited investors. So that just shows you that the vast bulk of offerings are only to accredited investors, which makes general solicitation, the elimination of general solicitation, potentially valuable for the vast bulk of Reg D offerings.
Okay, so Rule 506, like I said, it's a safe harbor. It's got a number of requirements you have to satisfy. Well, currently, to make use of a Rule 506 offering, you can't make use of any general solicitation or general advertising. If you do, you blow your Rule 506 exemption and you've got problems. General solicitation is pretty broad. I mean, it really is what it is, what it means. It's advertising, it's radio and television ads, it's seminars. It's really any sort of communication that's designed to get the message out that you're trying to raise capital. You can't do it in a Rule 506 offering. What you can do, and what you're only supposed to do, is rely on your pre-existing substantive relationships. So if you're doing a private offering currently under Rule 506, you're really supposed to only be soliciting those folks that you have an existing relationship with. If you start expanding out and going beyond to new investors, you really run the risk that you're going to be deemed to have done a general solicitation, and that's going to draw the validity of your exemption into question. So as I said, the proposed rules for 506 came out last August. The final rules came out this July. Just to give you a sense of what the SEC was dealing with when they put out the proposed rules, sort of the mindset, there were some comments issued by one of the SEC commissioners in August when the proposed rules came out. She said, in the time since the Commission promulgated Regulation D, technology has fundamentally altered the way that people communicate with each other. These advances in and of themselves should cause the Commission to consider whether to modify the current regulations governing the ways in which enterprises communicate with prospective shareholders and other investors. We need to be cognizant that allowing general solicitation in the private offering market is a profound change in the laws governing the offers and sales of securities. As with all changes of this magnitude, there likely will be unintended consequences, and we need to understand these consequences and consider, within the bounds set by Congress, how to adopt a rule that mitigates any unintended harms. So the SEC really saw that there was a tension between trying to implement what Congress had directed to remove the prohibition against general solicitation to sort of ease those restrictions, but then also have in the rule enough investor protections to keep these unintended harms from becoming too widespread. And not to harp on this, this is obviously part of the Jobs Act. Since these rules have come out, clearly the intent of the Jobs Act is a commendable idea that it's going to benefit a lot of people to encourage capital formation. But as the proposed rules have really started to, coalesce, it's been clear that there's plenty of critics out there as well. For example, Ben will get into the requirements in more detail, but as he mentioned, sort of hinted at about the new requirements for verifying the accredited investor status of people that take part in the offering, it can be a burden, and a lot of angel investors are starting to see that these rules could actually be more trouble than they're worth. Tom Still is the president of the Wisconsin Technology Council and the Wisconsin Innovation Network, and a couple weeks ago he wrote an opinion piece that was in the Journal Sentinel. The title of it was "SEC's Angel Rules Could Hurt, Not Help Startup Firms." And he sort of summarized his position. And perhaps the law should be renamed the Jeopardizing Our Business Startups Act, because that's precisely what the SEC rules will do if the nation's angel capital industry is buried under a mound of invasive and unnecessary paperwork. So it remains to be seen how this will all play out. The rules become effective in just a couple weeks, and it'll be interesting to see how everything plays out. Regardless of how it actually comes to pass, the intent of the rules will be very broad. The act was the Jumpstart Our Business Startups Act, but the impact is going to go far beyond startups. So for example, for private equity groups, hedge funds, venture capital funds, currently you're supposed to only be relying on pre-existing relationships when raising capital in a 506. Now you're going to be able to cast a much wider net and really look beyond those sorts of relationships for new investors. Startup companies, it's obvious. When you think of startup companies now, what sort of pre-existing relationships do entrepreneurs have with investors that have capital? Probably not a whole lot. There's demo days that startups can go to and try to attract the attention of angel investors. But beyond that, it seems like startups have a pretty limited opportunity in a lot of instances to really try to raise new capital. Well, hopefully these rule changes should really have an effect on startups and give them a number of new avenues with which to go solicit capital. Even established private companies, probably not a lot of equity raises going on in private companies in many instances, but in the past, if they decided they wanted to and they didn't have really a network of investors, you could engage an investment bank or a placement agent, and you could rely on the pre-existing relationships of those entities. That's permitted under the rules. But now they won't have to do that anymore. If a private company decides they want to go raise capital, they can go out and do so. They won't need the services of those third parties. And even smaller public companies might find this to be a benefit. If you're a larger public company and you're eligible to use what's called a shelf registration statement on Form S-3, then yeah, you can tap the equity markets very quickly. But if you're a smaller public company that may have done an offering in the past, or you had a shareholder base that became too widespread, and you've been filing your 10Ks, but you're not big enough to use the Form S-3, if you want to go do an offering, you have to use what's known as the S-1 registration process, which involves a lengthy comment process with the SEC. Well, now with the rule changes, these smaller public companies may decide, you know what, it really doesn't make sense to go do this S-1 registration process. We'll just do a private offering under 506, and we can use general solicitation to try to attract some new investors. So the basic overview, and Ben really already touched on this, but there's two main requirements under the new Rule 506 for taking advantage of the opportunity to use general solicitation. First requirement is all sales have to be made to accredited investors, and the second one is the company has to take reasonable steps to verify the accredited investor status. These are two independent requirements, so if you don't do number two, but you somehow luck out and you happen, it just so happens that all your investors are accredited investors under number one, you still have blown the exemption. You haven't satisfied all the requirements. This gets back to the commissioner's comments that I was reading earlier. The SEC really wanted to make sure that they could address any unintended harms that may arise as a result of companies being able to use general solicitation. So one of the things they've baked into the rules are some new bad actor disqualifications. So if you've got a murky history with securities regulators, or you've actually had some convictions in that area, if you become associated with a company doing a 506 offering, or if you're a third party like a broker-dealer lending services to a company doing a 506 offering, that can blow the Rule 506 exemption. So companies are going to have a new burden to establish that the people that they're working with and the people, the officers of the company themselves, don't have these sort of bad histories that could cause problems with the exemption. There's really no limit on the types of solicitations that you'll be able to use. It's going to open up a whole you'll be able to use social media and any sorts of advertising, but it's not completely the wild, wild west of capital raising yet. There are still things to keep in mind on the anti-fraud rules. Sprinkled throughout the securities regulations are a number of rules that prohibit deceptive and manipulative practices in securities raising. The most common, well-known one, I guess, is Rule 10b-5 under the Securities Act, but they all sort of have the same requirements that you can't mislead your investors, you have to make all material disclosures, those sorts of requirements. Those rules still apply. Those haven't been changed at all by the rule changes. So it's important to keep those in mind and make sure that any offering materials comply with those. And we'll get into this in more detail later on. And as Ben mentioned, the new Rule 506, it's just that. It's a new rule. They haven't done away with the old rule, which is under Rule 506B. They simply added a new Rule 506C, which includes the option to do an offering with general solicitation. So before you start an offering with general solicitation, if you decide that, this may actually be burdensome, all the new requirements that are baked into this rule are going to be a problem, and you've had success in the past doing a private placement under the old Rule 506B, you can just do an offering under old Rule 506B. It's still available. It's just they've added a new option under the new Rule 506C. But and Ben mentioned this as well, but you just can't change direction midstream. So it's important to have your plan of attack set before you start the offering. If you are doing a 506C offering and you've done a general solicitation, you have to have a cooling off period before you flip back and do an offering under 506B. Ben?
All right. So I'll move into really what is the heart of the new rule, which is the accredited investor requirements. And to take advantage of the new rule allowing general solicitations, all sales must be to accredited investors. Basic requirements for being an accredited investor as an individual relates to net worth and income, $1 million in net worth, $200,000 of income. And by the way, those standards haven't changed since Reg D was first adopted. I think it was in the early 80s. So if you give effect to inflation, it would be much higher. And in fact, at some point, it's possible that would happen, that the standards may be raised. The only change that there has been, which dates from about 3 years ago, is that the net worth standard now excludes the value of a primary residence. So that is no. I hit the wrong button. There we go. All right. Before I was joking about Larry handling the controls here, and I'm the one who messed up.
Rightfully so.
There's additional accredited investor requirements that apply to other entities. The ones we tend to run in most commonly, entities are accredited investors if they have at least $5 million of total assets. Entities can also be accredited investors if all of their equity owners are individually accredited. So you can form an entity to pool together your money to invest, and as long as each person who invests in the company is accredited, then they can flow through that entity. Trusts can be tricky. Some trusts, like revocable trusts, you can look through to the grantor of the trust and look if that person's accredited. But other sorts of trusts or irrevocable trusts need to have at least $5 million of assets, and that can be quite a high standard for a trust. So the verification standards, and this is really where the rubber hits the road on the new requirements. As I mentioned before, in fact, most Reg D offerings are to accredited investors, so that's not such a big deal. But these verification standards will take some getting used to. And as Nate mentioned before, there's been a fair amount of complaint and pushback from angel groups and others already. I've had some clients, in fact, I've spoken to about this, and they're very interested, but they're somewhat reluctant when they hear about the verification requirements. Now, as I'm going to cover here, I think perhaps some of that might be a bit overstated, and I think there might be some potential avenues, but we're going to have to see how things play out. What the SEC did in the verification methods is that they did not have a list or a checklist of these are the verification methods you must take. Instead, they basically say that what you need to do is what's reasonable under the circumstances. It's a flexible standard. As I'll get to later, they did include 4 safe harbors, essentially safe harbors for individual investors, where if you follow those, you'll know you're okay. But otherwise, it's really a facts and circumstances situation, which the SEC felt, and I believe this is probably the better approach, not a perfect approach, is that circumstances can be so different for different issuers, different investors, and to try to have a one-size-fits-all standard for verification probably didn't make sense. But if you know that there's some routes that are definitely safe, but you can be flexible, that's probably the best way to go. And in terms of looking at acceptable means of verification, the SEC gave some guidance that there's 3 different things you'll look at, and I'll cover these in more detail, a little bit more detail as we go on. But it's the nature of the investor, the nature and amount of information the issuer has about the investor, and the nature of the offering are the key factors. The next slide really starts getting into nature of investor, because some investors are accredited investors solely because of their status. An example we listed there is a registered broker-dealer. A bank is another example. There are certain types of investors that just because of their status, they're accredited investors. So that should be pretty easy to verify based on publicly available data. The hardest thing is to verify accredited investor status for natural persons based on the net worth and income standards. I also frankly think that some of the entity standards shouldn't be too hard. An entity that has $5 million of assets probably isn't going to be reluctant to provide a recent balance sheet, for example, which might be sufficient. So those sorts of things won't be too hard. But the accredited investors for individuals, I think, will be the biggest issue, and we'll probably spend the most time on that here. For natural persons, a couple of examples that come from the SEC guidance about things that do or don't work. The SEC indicated that if you have actual knowledge of a person's accredited investor status, No additional verification steps are required. We gave, I think, what are the easy examples of a family member or close friend. I think you could be fairly comfortable that for those sorts of people, you should have actual knowledge of their credit investor status. There might be others who are closer to the line. I mean, let's say, for example, there's someone who the entire community knows is a very wealthy entrepreneur who makes a lot of private placement investments. I mean, can you say that that person, you have actual knowledge that that person's a credit investor? I think there's a good argument, yes, but we'll have to see how much risk you want to take and how practice develops. How well do you need to know the person? Is this someone you golf with at the country club? Is this someone who you've seen but you've never actually spoken to but you know is rich? What is it going to take, and how deep do you have to go in terms of getting verification methods?
I'm sorry. So just to take a step back, if you're going through the rule to allow for general solicitation, the SEC is basically saying, since you may not know the people that you're bringing in as investors, you have to make sure they are in fact accredited investors, or use reasonable steps to do that. And if you go to people and you say, okay, now I need to see name, rank, and serial number, your tax returns and the like, you have the risk of having a fairly chilling effect on the offering.
That's the concern, yes. And before I get into those sorts of things, I'm covering some things where maybe you can avoid going that deep. But at least in a lot of cases, and probably you're going to hear from your lawyers, including potentially me, that there's some risk if you don't do the things that are absolutely safe, because the burden to establish an exemption is on the issuer, and if there's a question, that might come back to bite you. But you should, and I'll get to things like record keeping a little bit later, but I think any issuer that's going to do a general solicitation should have a plan in terms of how they're going to verify, and they should look at each investor and say, if I'm not going to, what am I going to do for that investor, and have a file, have a spreadsheet, have both, where they are able to show, we looked at each investor and we did this, and for this investor we may not have gotten tax forms, but that made sense because whatever the reason is. So you really put the premium on being able to establish for each person who actually invests that you've done something that's reasonable to verify their status. Another example of something that might be fairly easy is, let's say the investor is an executive officer of a public company in town. That officer's compensation is filed publicly in a proxy statement. You can look there, see how much they make. It's already publicly available. You probably don't have to do much else than that because that's public information. Other third-party information might work, although I think probably if you're going that deep, we'll get to the safe harbor methods, and that's probably a better route to go than substitutes for that. One thing that I think might have a lot of promise in terms of both verification and the method of general solicitation are third parties who verify a credit investor's status. And some of them will be covered by a safe harbor, like registered broker-dealers. Some might not, and there's already some of these starting up. And these sorts of services, depending on how they're set up, might simply be an outside service provider for the issuer that just says, outsource your verification and pay us a fee and we'll do it. Some of them might actually view themselves more as portals, almost like a crowdfunding type portal, but only for accredited investors, where you've got where they're advertising to people who are accredited investors, say, come to us, give us your information so we can verify you, and we'll open up the world of private placements to you. And then they go to issuers and say, we've got all these people in our portal who we've verified, and they're interested in investing in private placements. Come to us, and you can access these people, and we'll help you meet. And I think some of these examples we have on the list here, like Second Market, I think that is their model. And in theory, that might be an exciting way to use general solicitation that gives you some comfort, as well as comfort both in terms of compliance as well as perhaps a good method of effectiveness. And the key might be diligence. What sort of reputation does it have? If you're going to pay them a fee, are you actually going to have access to investors? Are they actually going to do a decent job of verifying? And are they actually a registered broker-dealer or someone else who you can rely on their status, or do you have to do more work to make sure that if they're not registered, that they're actually doing a decent job so you can reasonably rely on them? now the safe harbors, and there's 4 safe harbors. The first 2, which I'll cover together, deal with documents that that support either income or net worth. And the SEC didn't call these safe harbors, but what they said is that if you follow these methods, you're deemed to have complied with reasonable verification unless you have actual knowledge that a person is not an accredited investor. And frankly, if you had actual knowledge, I think you're in some trouble anyways. These sorts of documents, I think these are the sorts of things that these angel groups and others are looking at and saying, holy cow, I don't want to provide someone with my W-2 or tax form or brokerage statements or bank statements. And that might indeed be an issue. I mean, one thing that I'm not sure if people are focusing on is that it permits redacting, which is a fancy way to say blacking out or crossing out certain things. So in theory, someone could provide a W-2, let's say, and the only information that's pertinent is income and name, and you could cross out everything else and just provide that document with just that information. You know, bit of a hassle, so maybe that's going to have the same obstacles to acceptance, but on the other hand, it's a lot less intrusive than providing an entire document, and I think the same would go with the other documents. For example, a brokerage statement. If you have $2 million in a brokerage account, all that's really relevant is your name, the date of the statement, the broker, and the total. Everything else is irrelevant, and either you don't need to include those pages or you can cross things out. So maybe that will get over some people's sensitivity about providing sensitive information. We'll just have to see how that plays out. But I think that at least holds the potential to cause some concerns of investors to be minimized. The next safe harbor, which goes back to that slide that had the third parties that provide services. For these 4 categories of third parties, written confirmation within the past 3 months from any of these is deemed to basically to comply. One is a registered broker-dealer, and I think registered broker-dealers are probably the sorts of entities that might be interested in setting up some of these portals and doing more than just being a simple verification service. And the other 3, SEC registered investment advisor, licensed attorney, or CPA, those I can see coming up probably more often in terms of a trusted advisor of the investor rather than someone that the issuer engages. So if you have an offering, maybe most of your investors are fine providing the information, but there's a few who say, I don't want to do it. An alternative is go to them and say, well, would your CPA who does your taxes and knows all about your financial situation, would he or she be willing to write me a letter verifying that you're an accredited investor under the standards? How about your investment advisor who knows about all your investments and maybe knows about your assets and liabilities? Could that person verify your net worth? Even a licensed attorney, although frankly I get a little bit nervous and I'm not quite sure whether I'd write such a letter, and I don't know if our firm has a policy on that, but in theory, a licensed attorney could do that as well. And any of those 4 people...
I'll be glad to do that.
And I won't mention anything to our firm's general counsel who gets worried about liability. So that I think offers some promise as a way to potentially be flexible to address investors who might have some concerns about the first 2 safe harbor methods. And the last exception really will be useful, at least for a period in time, for companies that are somewhat established, although obviously its usefulness will be reduced over time. And that is, there is an exception for people who purchase securities as an accredited investor in one of the issuer's 506 offerings prior to September 23rd, the effective date of the rule. So if you're doing an offering the day after, and you want to offer to your existing investors, maybe you have to because they have participation rights, and you also want to do advertising for other investors, you can go to your existing investors, and as long as they certified through the old-fashioned method of questionnaires and subscription agreements prior to the effective date of the rule that yes, I'm accredited, you can still just rely on that method going forward and then do your advertising and your extra verification steps for others. So that's probably a helpful exception as well. So verification considerations. I think the question here, it's a trade-off. As we discussed at the beginning, for general solicitation to make sense in advertising, I think you need to have a good plan and a good thought as to how that would work for your company. What's your target audience? How are you going to reach them? How are you actually going to get investors? Is it worth it? And if it is, or if you think it might be worth it, you have to carefully consider, okay, how much pushback do I think I'm going to get on the verification methods, and probably talk to your attorney, what sort of verification methods do we think make sense and are we comfortable with? And given all of that, decide whether or not you want to take the plunge. The old method of just relying on investor questionnaires isn't sufficient, although I still think that will and should be used in all cases. But the question is, what do you need that's extra? And maybe all you need that's extra is just some knowledge about the investor, as I mentioned, for some investors. Maybe what's extra for some investors is that the investor has enough public information out there that is sufficient. But for some investors, you're probably going to need something more, and that something more might be copies of tax forms to verify income, or copies of brokerage statements and credit reports to verify net worth, or a letter from a CPA or investment advisor, or something like that. Or in the alternative, you can just go through third-party service and have them take care of everything. But I think it's going to require careful consideration of the trade-offs, and as I mentioned earlier, effective record retention is imperative, because it burdens on the issuer to establish the existence of an exemption, and so you need to have the records that would show for each investor you did something that's reasonable to verify their credit and investor status. Next slide, which Nate mentioned earlier, I'm just going to try to cover fairly briefly, although I think it is significant. And the first point is, although this bad actor disqualification provision came in at the same time and to some degree to respond to critics of the general solicitation rules, it applies to all Rule 506 offerings. So even if you do an old-fashioned 506B offering without general solicitation, you're still subject to the bad actor disqualification provision. So that means this is going to apply to pretty much all private placements, since, as we said earlier, nearly all private placements are 506 offerings because they're so flexible, with having no limit on the number of accredited investors and no dollar amount and other advantages. The bad acts that are relevant, or the persons whose bad acts are relevant, includes obviously the issuer, includes insiders of the issuer who shouldn't be too much of an issue, or at least hopefully you'd know and should be fairly easy to verify. A couple of categories I want to focus on. One is 20% beneficial owners, and I think the practical advice here is, if you're an early stage company and you're going to have a big investor come in and have a good chunk of the company, I think you should probably vet that investor if you're not already doing so on the front end, because if that investor has an issue and you're looking to do your second round, this could be a big problem. So I think it's imperative to really do some diligence on your major investors in the early stage if they're going to have more than 20%.
Is there any time limit? So if you have a person who was convicted 25 years ago of a securities-related issue, is that person still a bad actor?
Yeah, I don't believe there's a time limit. There is a, and I'll get to this, there is a difference between pre-September 23rd, 2013 and post. For someone who has an issue before September 23rd, 2013, all that's required is disclosure, written disclosure to investors, which in and of itself could cause some heartache. Although if it's relevant, you probably should be disclosing anyways. But you can at least continue with your offering and say, for example, you have this investor who had this issue and this is what it is. But for issues that come up after September 23rd, 2013, that's the disqualification. So it's really based a bit of a grandfather or ramping in process.
So Bernie Madoff is good to go, right?
Bernie Madoff is good to go, although the disclosure for Bernie Madoff's involvement in offering would probably kill the offering. The other category I just want to mention is this last thing, which we described as placement agents and their controlling persons. I think the technical language of the rule is something along the lines of anyone you pay or you compensate to solicit investors for this offering. And I think that's something to be careful with. Registered broker-dealers can have this issue. I mean, it could be surprising how often there's orders or other issues with even the most well-known broker-dealer firms. And then, as many in the room may know, there's this whole universe out there of unregistered people who help people raise money. And by no means all of them. There's a lot of very reputable ones, but some of them are actually unregistered because the person running the firm can't be registered because they have an issue. And you want to stay away from those because those sorts of people who you pay to raise money for you will lead to disqualification or at least disclosure if it's before the effective date of the role. Next page gets into the disqualification events. I'm not going to spend really any time on that. I mean, they're fairly clear-cut. There'll probably be some questions. I think the bottom line is it's the sort of things that I think you can cover in questionnaires or representations and warranties from the appropriate parties. And the real issue is what happens if one of these things come up. As I already mentioned, the effective date is September 23rd, so that's the key distinction between whether it's disclosure versus just being disqualified from relying on the exemption. And there's an exception from the disqualification or disclosure if the issuer did not and could not have known after exercising reasonable care that a disqualified person participated in the offering. So that's basically a due diligence requirement. And this provision received a fair amount of feedback and debate with the SEC in terms of how much is required. In my view, at a minimum, I think every issuer should have some sort of questionnaire or representation or warranty. So for example, I think that for your existing directors and officers, you should have them at least sign a document saying, I'm not subject to any of this, just because I think if there is an issue, you at least want to show that you asked. You probably don't have to do much more, if anything, for those people, assuming you know them well, they've been with the company for a while, you think the chances of an issue are pretty slim. The issue, and I think for third parties like placement agents, broker-dealers, finders, whatever they might be, I think you should have representations and warranties in your placement agreements or your engagement letter or whatever it might be where they tell you I don't have any issues. The question is whether or not you need to do more than that. Do you need to actually do background checks? And the SEC didn't really come to a firm position on that. And my position on that may change. My initial thought is that it probably depends on the facts and circumstances. And if there's someone you know pretty well, I think it's probably overkill to do background checks. I think if there's someone you don't know very well, especially if it's a third party where there might be some reason to question their status, like for example, someone who's not a registered broker-dealer who's helping you raise money, I think you probably have to do more rather than less for those sorts of people. So I think that there needs to at least be something done, and the amount that's done probably varies based on who we're talking about. One thing I should mention too is that there is the possibility for a waiver from the SEC. That's probably not going to be an easy process, but I'm guessing that investment banks that have issues that play in the private placement market will probably seek waivers because they don't want to be technically disqualified from this line of business. I'm guessing for most individual issuers, especially if they need capital and they don't have the time to wait, like they have a director or someone else like that who has an issue, they're probably not going to be able to spend the time or want to spend the time seeking a waiver. So in that case, if it happened after September 23rd, 2013, the answer is going to be probably disassociate yourself from that person before you're offering, or you can't rely on Rule 506. And he'll turn it back to Nate.
So I just want to touch on a few things to think about when you're putting an offering together, and then we'll run through a couple examples about how we see this really occurring in the real world. So one thing to think about is, and we've touched on this before, is that once these new rules come into effect, there's no limit on the type of solicitation that you can use. Use your imagination, and it's probably permissible. It's a really fundamental change to this rule. It's going to open up a lot of new avenues to capital raising that weren't available under the old rule.
One thing I wanted to mention just on the slide, I noticed discussions with media, and I think that's a possibility. I will advise my clients to exercise care because previously I'd always get nervous if you have a young startup company you're representing and they decide, oh, I have this great opportunity to meet and have an article in the Journal Sentinel or the Business Journal or something like that touting my business. And I would say, great, but that might be a general solicitation, especially if they mention you're raising capital and perhaps even if they don't. This in theory eliminates that concern, but my new concern would be, well, what are they going to say about you, and are you responsible for the contents of that article if it's used as something to promote your offering? So I still think you probably need to be careful, or at least have some decent comfort that that article isn't going to contain something that is going to raise 10b-5 anti-fraud concerns about how it's hyping your business.
And this point, we've mentioned this before, so I mean, no need to beat you over the head with it. The idea is we don't really know how investors are going to react to these new information verification requirements. So it's something to think about when putting an offering together. Is it really worth using general solicitation if it's just going to result in chilling all the people that you're trying to have invest? And keep in mind that if the new 506C, you don't like it, you don't think investors are going to react well to the verification requirements, you can still use old Rule 506B. You just can't use general solicitation, but it really lowers the requirements that the information that investors are required to provide for you.
Nate, just a quick question on that. Let's say you start out with just the traditional private placement and you take a book around to the logical suspects in the area or in the marketplace that you're going, and you raise 3/4 of what you targeted to raise. Can you then go and do the balance of the offering through 506C?
I think the offering will all be integrated, and you're going to have to verify everybody that contributes capital in that offering, even the people that contributed on the front end.
Yeah, I think that's right. I think you probably could go back and verify after the fact. I mean, it's not clear, but I don't see why you couldn't go to your investors, investment, and say, hey, we want to open this up. We think it's going to help us raise more money. Are you willing to provide some additional information so we can do that? And maybe also your usual suspects are people that you'd be comfortable don't require much verification. But depending on who they are and their willingness to cooperate, that might be a hard call in terms of whether or not you need to either wait 6 months, which is the safe harbor for cooling off. So your first offering is perfectly valid. You just have to stop your offering activities, wait 6 months, and then launch your new 506C offering. That probably is what you'd have to do unless you can feel comfortable that you can satisfy verification for all the existing investors.
The next slide here is, really the message here is work with your advisors. This is a fundamental change to how these offerings are going to be conducted. When the new rules come into effect, no one really knows what the practical implications are really going to be. How are investors going to react? What sorts of verification techniques are going to become commonplace or accepted or deemed to be a best practice? So when you're first setting off on this new offering and using general solicitation, work with people that have done it before. Make sure you have a very clear plan as to, first of all, whether you're going to do an offering under new 506C using general solicitation, or if you should just use the old one under old Rule 506B. What you don't want to do is start off on the 506C and then have to revert to 506B. Then you have that cooling off period problem. So make sure you come together with a plan for that. And then if you decide to do an offering under 506C, work with your advisors to come up with a concrete plan for how you are going to handle the verification requirements. And then something to keep in mind, and I mentioned this before, but the anti-fraud rules still apply. So it's Rules 10b-5 is still in effect, and all the other anti-fraud rules that are sprinkled throughout the securities laws are still there. So obviously, anything that you distribute to investors cannot be material and misleading. You really have to scrutinize the content of anything that you're putting out there for anything that, any material omissions, any material misstatements, anything that could be construed as misleading about the offering or about the subject company.
And Nate, one thing I want to mention there is that it's well known from the SEC comment process that state securities regulators are not too thrilled about this rule. They were probably the leading vocal opponents to a number of aspects of it. And they're going to see your advertising and solicitation materials. And state securities regulators are empowered to bring actions or ask tough questions on where they think there might be fraud. So I think that is a good reason to be careful about the content of advertising, is that even if the SEC isn't going to be there breathing down your neck, the Wisconsin Division of Securities might be. So again, exercise caution.
And then one thing to think about is, right now there's a proposed rule that's floating in front of the SEC that would require any sort of solicitation material to be accompanied by a cautionary legend. It basically would say that, warn you that this is a speculative investment, and also letting you know that only accredited investors can take part in this offering. Those rules aren't final, they haven't been passed yet, but it really is good advice that any sort of solicitation material that you're putting out there, there's nothing wrong, and it's certainly helpful to have a warning statement attached to that. Consult with counsel on this. We see so many materials that companies are preparing that they're sending out to people that they're trying to raise capital from, and there's always anti-fraud concerns, and it really is very scary sometimes, particularly now when these companies are going to be able to solicit people that they actually weren't exposed to before. So anti-fraud concerns may be a bit more limited when you're dealing with people that you've done business with in the past. There's sort of a known course of dealing with. But now if new investors are coming into a transaction that you aren't familiar with, it seems like there's a heightened risk that down the road, if the investment goes sour, those people don't have the years of history, and they may be more willing to bring a securities fraud claim. So the best practice for protecting yourself against a securities fraud claim is to prepare a disclosure document. It's very similar to prospectus. In the private placement realm, you call it a private placement memorandum or an offering memorandum or something like that. But the concept is the same. It's basically you want to get in the hands of the investor all the material information about the company and about the securities that are subject in the offering. Just want the investor to be able to make an informed investment decision when deciding to purchase the securities. Mechanically, there's a requirement which can be a bit of a pain, and it's probably going to be a big road bump for a lot of startups. If you're claiming the Rule 506 exemption, you have to file what's known as a Form D electronically with the SEC within 15 days following first sale. The form is pretty basic. It's 3 pages, and it really just asks for a lot of factual information about the sale, the name of the issuer, the number of investors, the amount of capital raised, those sorts of things. It's easy enough to complete. The problem is you have to submit it electronically to the SEC. So first, that involves submitting a notarized document to the SEC. You typically have to call up and deal with an extremely rude SEC person there on the phone. May or may not be helpful. Then you have to go back online and jump through a few more hoops there, and you get these 4 very long and senseless codes. And then once you have the codes, you have to understand how to interface with the SEC's EDGAR system, which takes a little practice in and of itself. So for public companies, this is no big deal. They're used to making these filings. But if you're a startup and you're trying to do a Rule 506 offering, to actually jump through these hoops and actually do this filing could actually take a fair amount of resources that you may or may not have.
And just to plug Reinhart briefly, we can handle all of this for our clients. We have the capability to do EDGAR filings, get the codes, do all of that, and we do that for Form Ds and for public company filings too. So we just want to walk through 2 possible approaches for a company that wants to go out and use general solicitation to raise capital. So this is sort of the do-it-yourself approach. The first step is obviously to come up with the solicitation or the advertising material. However, you're going to draw attention to the fact that your company is trying to raise capital. Now the issue is with the anti-fraud concerns, you can't get all the material information about the company and about the offering into the solicitation material. I mean, really, this is just an attention grabber. So the idea, as we see it, would be to say you're doing an email blast. So in your email blast, you include a link back to an investment page on your company website. The website then, so someone would get that solicitation, they click on the link, and they go to the investment website, and it's going to have, first of all, the details of the offering. So the amount of capital that you're trying to raise, the type of securities, when closing is going to happen, those sorts of things. Then you can discuss on the website how you're going to go about doing the accredited investor verification. You can add your disclosure document, your private placement memorandum for the investors to take and peruse, and then also the investment documents. It's a private offering, so it's a little bit more complicated than purchasing shares in a public company. You just don't send off a wire and end up with a stock certificate or a book entry position.
there's going to be a shareholders agreement or an operating agreement. The company's going to want to have transfer restrictions, possibly redemption rights or various other rights and restrictions that the shares are going to be subject to. So all the legal documents that the investors are going to be expected to sign can also be available on the website.
And I think one thing to be cognizant of here is if you're going to a group of investors who you may not know as well, I mean, that's probably all the reason to give careful consideration to things like what sort of buy-sell arrangements you're going to have, how can they transfer shares, who might my shareholders be, what rights do they have to information, how can we limit that. Some considerations that frankly might be more relevant to a public company. You wouldn't be a public company, but you might have a larger group of investors less well known to you than you would be under the old method where you're just going to people you have a pre-existing relationship with. So there's some advantages to this, but one disadvantage, which we haven't really focused on, is even if this all works and you raise a lot of money, great, but you might raise money from 50 accredited investors from different parts of the country who really you don't know very well, who might or might not be good shareholders.
Another thing, practically, if you're giving information to people you don't know, you may be giving information to people who might use it adversely to you, such as competitors. So I think in any case you're going to need to have some kind of screening method so that you can make sure those kinds of people don't get what they shouldn't get.
And I guess this goes along those same lines. But the information that you're going to be putting out there may be sensitive. It may have harmful information and also just negative information about the company. The private placement memorandum is not only going to discuss the possible benefits of the investment, but also the risks and the downsides that could possibly occur as well. So think about whether this investment page that we're talking about should be available generally to the public. It might make sense when you have your initial solicitation material to direct that person to say, hey, contact our CFO or contact some other officer at our company. That person can decide whether the investor has demonstrated a sufficient level of interest that they should be given more information, or even at that stage you could verify right away that they're an accredited investor. And only at that point then could they be given the password or some other way to access the rest of the investment documents. So that's sort of the do-it-yourself approach if you wanted to sort of strike out and try to raise capital on your own. Another way is to sort of outsource it. In the rules, the SEC even acknowledged that it's probably likely that there's going to be a number of third-party platforms that are going to rise to really serve these new offerings. One that we've already come across online is this company called Second Market. Before Facebook was public, Second Market served really as sort of it was basically a trading platform that you could do private transactions in Facebook shares, and they made a market in those shares. And then when Facebook went public, that revenue stream fell away from them, and they sort of had to look for a way to retool themselves. Jobs Act comes out, and they see an opportunity. So they've kind of reinvented themselves as catering to companies that want to do an offering with general solicitation. And I haven't really delved too deeply into the site, but it looks like from what the first few screens of the website, they're going to try to provide a full spectrum of everything you need to do a private capital raise. They'll track your investors. They'll deal with the accredited investor verification. They'll have all the closing documents that you need, any sort of escrows, those sorts of things. So it's something to think about, and inevitably I would imagine there's going to be other services that will rise that will be competitors, and a few good ones will probably float to the top. But it's another option if the do-it-yourself option is a bit too burdensome.
Yeah, it appears from their website like they might be an example of what I was talking about, where they're trying to be a platform or a portal that appeals to both sides. Trying to appeal to investors, get them to submit information. Basically with the idea, like with Facebook, this might be a way for the ordinary investor, albeit accredited, to have access to investments they might not otherwise have, and then they can turn around and market to issuers saying, we have this great group of investors who have indicated an interest in who we've verified, so come here and market your offering. So in theory, something like this, whether it's this company or someone else, could be a powerful way for this to work if everything comes together.
And then Ben will discuss a few of the proposed rules that are floating out there right now.
Right. Well, we already talked about the bad actor rule, which was a little bit of, I suppose you might call, bad news in connection with the general solicitation reform. Some other potential bad news, in theory, depending on how you view these things, might be some of these proposed rules. And again, this goes back to the same theme of there were parties, state securities regulators, what you might call consumer groups for investors, and others who were concerned that this would open the door to fraud and all kinds of concerns, and the SEC should not just let this go, as a simple, straightforward rule that says general solicitation is permitted. And so what the SEC did is they not only did they passed the rule that's effective September 23rd for advertising, they passed the bad actor rule that's effective September 23rd, but then they also threw out some proposed rules. And at this point, these are only proposed rules, and given the SEC's normal timing, it's doubtful these would be final rules before sometime in 2014, if then, I suppose, if ever. But these are out there, and I think we should be aware of them, because if they do come, they might create some additional roadblocks and issues for some of these offerings. And the first set of proposed rules deals with Form D, which Nate had covered. The Form D is something that currently you file. It's a fairly short, simple form that gets filed electronically within 15 days after your first sale, which is sort of nice because you don't have to worry about filing it until your offering actually results in sales. So you can proceed with your whole process of putting your book together, however you're marketing your offering, doing that. And then before you have a closing and actually have sales, you don't have to worry about filing the Form D. And the Form D gets filed not only with the SEC, but also with most states. So it's a filing that you'll see in both places. It's mostly informational. In fact, the statistics we were citing at the beginning of the presentation about the Reg D market mostly comes from the SEC hiring a third party to study all the Form Ds that get filed with it, so it creates a base of information. State securities regulators like them because they can keep tabs of the private placement market and look for things that might raise issues. So the Form D changes, timing. For offerings that use Rule 506, an initial Form D would be due 15 days in advance of the use of general solicitation for the offering. So that would be a big change. No longer can you go out there, market your offering, raise money, and then worry about the filing after you've raised your money. Now you have to file the Form D. If you're going to use general solicitation, within 15 days of your first use of general solicitation. So that will require some planning if this rule comes into effect as proposed. And then for these sorts of issuers that use general solicitation, an updated Form D would be due within 15 days after the first sale. The initial Form D isn't the entire form. It's just going to have some selected information about the issuer and its method of offering. One of the changes to Form D that's actually effective now is that there's a checkbox where you check, is it a 506B offering without general solicitation or a 506C offering with it? So that's something that you'd want to do, but there'll be some other requirements, which I'll get to later, new requirements for Form D that's going to provide more information about the general solicitation. Then the updated Form D would just cover, whatever else you need to add plus any changes, and that would be consistent with the timing of the Form D for those issuers who don't use general solicitation. And the new requirement for all issuers, whether you use general solicitation or not, is a final Form D is due 30 days after completion of the offering, whether completion means you raised all your money and it's time to stop, or whether completion means you didn't raise your money and you just have given up and are terminating it. I think this is because the statistics that we gave you should be taken with a little bit of grain of salt, because there's not any current requirement to have a final Form D filing, so a lot of issuers don't. There are some amendment requirements that there's significant changes, but you might have an offering where you say, we're looking to raise up to $5 million, file your first form saying the first $1 million has come in, never change it. So someone looks at that form, well, how much did you raise? Did you raise $5 million? Did you raise $1 million? You might report that, oh, we had 35 investors, all of whom are accredited. Is that the final number? Did you have more? So the purpose of the final Form D is to basically tie things up and provide the final information about the offering. Expanded information requirements for Form D. Most of those will be no big deal. A couple of things that I wanted to highlight about the additional information requirements. deal with general solicitation. One of the proposals is that you include information about the types of general solicitation used or to be used. And this might evolve, but the way it currently looks is basically like a checkbox. So think of a checkbox, social media, a checkbox, investment seminar. But they want you to check everything that's relevant in terms of the general solicitation so they can keep track of that. And another requirement is methods used to verify accredited investor status. And again, it's going to, I think, be in a checkbox format where you might check a box where you relied on the safe harbor for tax forms as to income, or you relied on this or that, and you might have multiple check boxes, which I think is going to be a bit of a pain and not too useful, especially if people end up tailoring what they rely on to the investors. You might end up checking every box because everyone is relevant for one investor or another. But in any case, that is at least a proposed requirement that would increase the burden of the Form D filing. A couple other things changes might be somewhat burdensome too. Currently, you only have to provide information about how you're using your proceeds if it's going to a related party. But the proposed change would be you'd have to provide information on how you're using your proceeds regardless. So that may or may not be a big deal, but you'd have to disclose using it to expand the plant or whatever it might be. Failure to file Form D would disqualify issuer from new Regulation D offerings for a year. This is a fairly significant change. Currently, the rule, and this was a change that came into place, I forget, quite a while ago. It used to be where filing a Form D was a condition to the rule, and if you failed to file a Form D, you couldn't rely on the exemption. Currently, that's been eliminated, and basically all the rule says is that the SEC can bring an enforcement action if you fail to file a timely Form D to prevent future use on the exemption. I frankly am not aware of any such enforcement actions. I don't know if they've ever happened. They may have. It's exceedingly rare. So some, in fact, probably many issuers might decide we're not going to bother with the Form D. This is meant to put some teeth into it. And the notion would be that if you had an offering within the past 5 years where you didn't do a filing, you would be disqualified from using the Reg D for a 1-year period that starts when you make your required filings. The proposal is a little unclear as to, well, if you never actually make the filings, are you good to go until then? So it's not clear whether you'd still need an SEC enforcement action to sort of start the process, someone saying, hey, you have to file, and then that starts the 1-year clock ticking. But in theory, this might put more teeth into the Form D filing requirements and probably make people like me say even more strongly, you got to get the filing in on a timely basis. Next proposed requirement is that written solicitation materials would be required to contain certain required legends and cautionary statements. And I think this is somewhat similar to what Nate was talking about earlier. And I think probably this, as Nate said, this makes a good sense to do a certain degree of this in any case before this. So this is one of the rule proposals that I think makes some sense, although the problem with these sorts of legends and requirements is that you're going to get SEC written boilerplate that you have to include rather than tailoring it to what you think makes sense for your offering. But at least some degree of cautionary statements make sense, I think. Next proposal, that issuers would be required to file written solicitation materials with the SEC, at least on a temporary basis. I don't think this makes a heck of a lot of sense. I'm not quite sure what the SEC is going to do with it. The plan is to require companies, in theory, to file this electronically through a non-public website, which means it would not be publicly available. But I guess if there is a fair amount of activity in this area and this requirement comes into effect, what the SEC is going to have is a huge data dump of a bunch of general solicitation material. Who knows what the SEC would do with that? But
we should probably get to questions if we can.
Running out of time?
Yeah.
Okay. Well, let me move on quickly. I think the last 2 slides I don't think I need to spend much time with. Undoubtedly, when these things happen, we'll have more on this. Crowdfunding, I know, excites a lot of people. Crowdfunding rules have not yet been adopted. My last question, I think, is a pertinent one. Will the burdens on crowdfunding make it useless? And I'm happy to talk to anyone about the flaws in the crowdfunding legislation because there are many, and in my view, it's probably a great idea that's never going to take flight because that is the one area of the Jobs Act where I think after the House passed the bill, the Senate decided to take a hand and write in some requirements, and Senate got all concerned about investor protection and wrote in a bunch of requirements that I think will make crowdfunding impractical because it'll be too costly and too risky, and it's already subject to limits where it's going to be hard to raise much money. So you've got crowdfunding would involve a bunch of small dollar amount investments from a lot of unsophisticated investors. Who knows how much you're going to raise, and then depending on the amount you're looking to raise, you may have to do things like have audited financials, file documents with the SEC that probably need to be reviewed by an attorney. All that is expensive, and if you're talking about a small offering of $1 million or less, it doesn't make a lot of sense to spend $50,000 on accountants and attorneys and crowdfunding portals and whatnot. So I'm pretty dubious this is going to be very useful. Next in the Jobs Act is what's called Regulation A+, which will supplement or replace a little-known and little-used Regulation A exemption. I actually think this might have some possible use. It's almost like a mini public offering. It's not really a public offering, but it'd almost be like a mini public offering up to $50 million. And you do have to file documents with the SEC, but you don't actually become a public company after it's done. And the shares that are issued could be traded, so in theory, there might be markets that develop, not limited to accredited investors. Potentially, you don't have to worry about state blue sky filing. So there's all kinds of reasons to think that if this comes out ever from the SEC in good form, this might result in something that could be useful for some companies that too small to go public, doesn't make sense to be a public company, but needs to raise capital of the, $10, $20, $50 million range. The private placement market isn't working. Maybe they can do one of these and have something that might be useful. And I think we've moved on to questions. So I invite anyone in the audience, or I don't know if we have questions from our online audience.
John?
Yes, I guess maybe this is too big of a question, but how does all this relate to state securities laws?
Let me repeat that for the people who are on the website. The question is, how does all this relate to state securities laws?
Yeah, thanks, Larry. I actually forgot to do that for the website audience. The answer is that Rule 506 currently, the old Rule 506 and the new Rule 506 preempt state blue sky laws, which basically means states cannot require separate registration or additional requirements. So that will continue to apply, which means that all states can require is a copy of the Form D filing and a payment of a fee. So that regime continues in effect. So that means that you can do these sort of public offerings to accredited investors without having to deal with a bunch of state filings.
Yes.
I'm just wondering, it seems like I've seen in the news arguing crowdfunding where they didn't understand the articles were accurate, but it's something that isn't implemented yet and is not happening.
Yeah, the question was whether people are currently doing crowdfunding because there have been news reports on crowdfunding. I think what you see in crowdfunding, and this has been something that securities regulators jumped on for some companies across the line, but what you've seen from crowdfunding from sources like Kickstarter is things like donations, or you might have a company that has a great new product, and what they solicit is pay some money and you might get some free product or some other benefits. But what you can't see, or what you shouldn't see in compliance with the securities laws, is a crowdfunding offering that actually offers an investment, shares or debt instruments or whatever it might be. So that's really what the SEC crowdfunding rule would allow, is investments in securities through crowdfunding rather than donations or product or whatever it might be currently.
Now, I think Wisconsin, there's either a bill pending right now or it was just recently passed, but it creates you can do crowdfunding, but it's got to be just intrastate investors. So if you keep it all within the borders of Wisconsin, you stay out of the SEC regime. And I don't know if it just passed or if it's just been sort of discussed, but that's out there as well.
Just this isn't a question, it's sort of an editorial comment on all of this. I want to relate to something that came in the office probably 3 or 4 years ago, where an individual, an entrepreneur, was looking to raise capital, and he came into me and said, I understand I can do a wholly intrastate offering and advertise it under Wisconsin law. And my response before, without even checking with somebody who actually knows, namely Ben, was, if you can do that, that's great. However, I would be very surprised if any accredited investor would actually raise their hand and respond to your advertisement. And the reason I said that was because in my experience, it is a relationship-based world. And especially, maybe it's not true in California or New York or Boston, but here in the upper Midwest, who you know and how they have come at an investment in a company makes a great deal of difference. And I felt that it was unlikely that any accredited investor would actually raise their hand and call this company up and offer to invest in their company. So maybe that's changing. Maybe I'm old school or something, and maybe this will have an effect on that. And certainly the Wall Street Journal article was very enthusiastic about the possibilities. I still think that before you do anything like a general solicitation or advertising, you really need to think strategically about whether or not that makes any sense at all. And the question might be, under what practical business circumstances might there be a use for this? And I can think of a number of situations where, in fact, advertising, not generally, not on WISN radio or in the Journal Sentinel, but discreetly may very well make sense. For example, in early stage drug development, if you have a drug compound that's targeting a specific affliction, and there is an organization that's supporting people who have that affliction, it very well may make sense to reach out to those people who have a vested interest in that. Or, for example, if you take the aviation industry, which is a sort of mind-boggling niche in and of itself, because I don't know anybody who actually ever made any money in that business, but they are devoted to it. And you have an offering of a new aviation product or technology, maybe it makes sense to reach out there without necessarily knowing people. I'd be interested in hearing from the audience, perhaps, whether or not that's my perception's on the money or maybe it's off. Roger?
Well, I think you're spot on.
Yeah, I mean, I think that's consistent with my thought of niche advertising. You could probably get creative and think of all kinds of products that have their niches, but I don't think, going back to the Wall Street Journal article, that billboards or things like that are going to work. I think that's frankly kind of silly. But I think if you can target it for a good niche that makes sense for your product, it could work.
Any other questions? Yes?
How do you get, like, the entrepreneur or non-accredited investor to these corporations?
Yeah, the question is whether or not employees and people like that can invest in these sorts of offerings that are limited to accredited investors when in many cases the employees are not accredited. And that's an issue I run in a lot currently because, frankly, even under the current regime for Reg D, having a non-accredited investor is not easy. The disclosure requirements are pretty stiff, which is why, as I said earlier, approximately 90% of Reg D offerings currently are solely to accredited investors. And really, there's not a real good answer to investing the offering. I mean, a lot of times what I try to explore is whether there's some way you can make some sort of compensatory arrangement. It doesn't always work, and a lot of times you want the person to have skin in the game. But there is a separate exemption for compensatory arrangements that are not integrated with separate Reg D offerings, even if they happen simultaneously. So maybe there's some way you could structure something that's compensatory. Maybe it's just without an investment decision, your bonus is paid in stock or something like that. So that's one route. Other than that, what I've done with clients is try to explore ways to fit it into an exemption, but I think that would be precluded from this new 506C for general solicitation, unless, again, you do something like a waiting period.
80% to tell 80% of the company, but you're going to get tell 100% of the company, but you're going to get 80%. In having the perspective that 20% is going to be designated management.
Yeah, the point being made is whether or not you could designate some portion to management or like 80%, for example, and 20% to the employees. And how would you suggest that the 20% be issued to the employees? Are they going to actually pay the full price?
3 or 5 years, 10 years, something like that.
Yeah, I mean, you can do that. Again, it needs to be compensatory to have the exemption. So if you can legitimately say it's compensatory and it's not part of the capital raise, and they're not coming in as investors like any other investor in the capital raise, then that's fine. So you can do some sort of compensatory pool for management or for employees, and you can rely on an exemption for compensatory arrangements, and you can do that at the same time that you're out there raising money for the rest of the capital structure for outside investors through general solicitation or otherwise.
Sort of an irony in this whole thing, and I'm in Ben's office slapping my forehead a lot on these rules. But the irony is that you want employees to have skin in the game, and you want them to get really good tax treatment. But if you comply with the securities laws and have non-accredited investors, you want only accredited investors, it's really difficult to get employees capital gain treatment with this regime. So they'll get ordinary income instead of capital gain, but they'll have been protected for the little bit of money they would have put in on this. It's just sort of irony.
And one thing that just occurred to me, it's a little legalese here, but I think it's relevant, is that one way that the general solicitation might be a game changer is that previously, if you had an issue with your Reg D private placement, remember it's a safe harbor for an offering that is not a public offering, and so you could always have some comfort that, well, if I have a little footfall here or there, or maybe one employee who invested who's not accredited, I'm still okay, because it's really, in the scheme of things, this is still not a public offering. The world is different if you're going to do general solicitation. If you do general solicitation and you don't follow each step in this new rule, you can't say, oh, well, I failed in that step, but I still don't have a public offering under the basic statutory exemption. No, that's wrong. Once you start advertising, you can't say, well, even though I didn't comply with Rule 506C, I have a good private placement, because advertising is inconsistent with that concept.
Steve?
Are the accredited investors objecting to the effort in the verification process or the disclosure of information?
The question is whether accredited investors are objecting to the hassle or the sort of the time spent providing the information, or the actual sort of confidentiality privacy concerns. And that is an excellent question, and I would like to know the answer, frankly, because I think that'll be key. Because as I mentioned, I think just thinking about this myself as, say, a potential investor, that through redacting and some other methods, you maybe can solve some of the privacy concerns. But if people just throw up their hands and say it's a hassle, I don't even want to deal with providing some documents that are redacted to make this investment, that's a whole nother ballgame. And I don't have a clear sense so far in terms of where the concern really is. I get the sense that people just think, oh, it's intrusive, and get the sense that the privacy is behind it. But I think you can deal with some, if not all, the privacy concerns.
I was talking to one of our partners earlier, Al Orr, and I was saying, well, I can't imagine, and you can think of some of the accredited investors who are pretty high profile around town, getting their tax returns or their investment statements, you're even asking them for that. But Al Orr said to me, well, you're just old, Larry, because young people, if they're accredited, share everything. Go on Facebook and look at that. So maybe it's generational. I don't know. I do think people are going to be very reluctant to share any kind of sensitive information with a company, particularly if it's somebody who's a total stranger. They're going to want to have some kind of protection or an intermediary to vouch for them.
Right. Again, I ask whether redacting or taking out information, is it that sensitive? If all the form really has is your name, the tax document, say, has your name and your income, is the amount of your income that sensitive? We know it's over $200,000. Is the exact number the sensitive number, or are you concerned about all the other stuff that might be in that form that you can just cut out? And I think that'll be the question. And my personal feeling is that the market might develop where people come to accept that, especially maybe it's a younger generation. I'm probably not quite so young as the younger generation, but thinking about it myself, I personally wouldn't have a problem providing some of that basic information to make an investment. So if there's others who think like me that this might actually work. Hopefully that's right. And any other questions? How are we doing for time?
We're good.
We're good. All right.
Thank you very much, everybody. We have refreshments in the back. Thank you.
Thank you. You did a good job.